The pressure on firms to do more with less or do more with the same is ramping up, but the cat's out of the bag at this point. Everyone knows at this point that AI is going to have a big impact on law. It's still sort of subject to debate, what this all looks like when the dust settles, how much of a disruption it's going to be, but it's going to have an impact. And ultimately, it will be a force multiplier, and it will have varying effects. I think there are a couple things to kind of keep in mind. One is that legal is a very diverse, in terms of the practice itself, right? Like the tasks that lawyers do, it's very, very diverse.
Welcome to Between the Briefs, a podcast by Steno. We're here to bring you practical tips, expert insights, and real conversations about the pretrial process, court reporting, and the legal technology shaping the future of litigation. I'm your host, Adrian.
And I'm your host, Joe Stevens. Whether you're an attorney, paralegal, or just curious about how technology is changing the legal industry, we've got something for you. Each episode will break down complex topics, share behind-the-scenes intel, and talk to the people leading innovation in and out of the courtroom. So grab a coffee and let's get into what's happening between the briefs.
Welcome to Between the Briefs, your go-to podcast for legal innovation. I'm Joe Stevens.
And I'm Adrian. Today, we're excited to welcome Kyle Poe, Vice President of Legal Innovation and Strategy at Legora. Kyle brings a rare blend of experience as both a former litigation partner at a global law firm and a leader at the forefront of legal AI innovation.
At Legora, Kyle works with law firms and legal departments around the world to apply AI in ways that don't just automate tasks, but fundamentally rethink how legal work is delivered. His background gives him a practical, grounded perspective on how technology can truly support lawyers rather than disrupt them for disruption's sake.
Kyle, welcome to the show. We're thrilled to have you here today. How are you doing?
Doing great. Glad to be here.
Love to have you here. Very excited about it. So let's dig right into it. Tell us a little bit about yourself, your history. From what we understand, you used to be a litigation partner and now work in AI for tech companies. So tell us more about that.
Sure, absolutely. Yeah, so after graduating law school, I clerked for a year and then went straight into a large law firm, Morgan Lewis, and their product liability group. And so when I joined the firm, I did first couple of years, all the traditional lawyer tasks, depositions, document review, even briefing. But early on, I got involved in, we had a large docket of cases, large product liability docket. And one of the things we ran into was that we had so many cases that we were dealing with, and the way that we were tracking it was rather shocking. I think it's actually a common experience for attorneys now as they're entering into law firms is, they're tech-enabled, tech-savvy, the way they grew up. Particularly nowadays, they're using ChatGPT in their daily life, and they're getting into firms, and then they're looking at the tech stack that is legal tech. And let's just suffice it to say that they leave a lot to be desired compared to some of the more consumer-grade technologies that are out there. And so just when I came in, this is quite a while ago, back in like 2011 when I joined the firm, the way that they were tracking cases, just basic managing this large docket of around 10,000 cases was incredibly antiquated. It was like a combination of Word tables and spreadsheets and paper files. And what I found was, sort of after I kind of learned the ropes, I found that our ability to track data and our ability to track those cases was really hindering our ability to take on new clients. It is also kind of inhibiting our ability to kind of see around corners. And I knew that there would be a role for technology to play. I, was a hobbyist growing up with computers. Didn't ever plan on doing legal tech or doing technology at all. But I just knew that there were things out there like databases that could be used to help solve some of these problems. And so early on, a couple of years in, I went to with partners I was working for, and I said, hey, we have this really poor tech stack. And if we were to spend a little bit of time building a platform or finding a solution, a technology solution to help us manage our cases better, could really solve a lot of pain points, but also unlock a lot of value for our business. And of course, the partner's like, sure, go ahead. Nobody else wanted to do this. So started working with IT really early on in my career to just go through the whole process of do we build, do we buy, a platform to help manage these cases. And because this was like 2013 era, there weren't, legal tech has come a long way. And so there are solutions kind of off the shelf that you could get today that didn't exist at that time. So we made the kind of fateful decision to build inside of a law firm, which a lot of people have kind of made those decisions, and kind of the risks associated with building are kind of well known. But we decided to do it. It turned out to be a really great idea. And so really, like I said, around midway through my career as an associate, I was able to build this platform out we're able to consolidate all of our data infrastructure for this one practice into a single place. And once you have all your data in one place, it makes it easier to find the data, because it makes it easier to see what's coming up for depositions, coming up for trial. It's easier to do things like assign people various tasks. But then once you have all the data in one place, you can start to do analytics on top of that data to actually inform the strategy of those cases. So informing, like, when do you settle? When do you take things to trial? Should we push, put pressure on this plaintiff attorney or on this other one? And then after you have that kind of solved, you then start layering in billing data, and then you can start to learn how to reprice the work. So it's really kind of solving the data infrastructure first, then this kind of case strategy, and then from there it's like business strategy. This all turned out to be a really great idea that we were able to kind of iteratively build. And so ultimately, I was kind of got a reputation for being the guy who could help take clients from hourly fee arrangements to fixed fee arrangements using technology, which is, of course, something that people are thinking a lot about doing now. And I was doing that about a decade ago, and made partner on the back of that, as well as kind of the practice itself. So managing these cases, I was asked by the head of the firm to take this platform that we had built to others in the firm, whether others could benefit from it. And it turned out that lots of people could. But ultimately, the technologies that we were using at the time were rather limited in terms of the number of the types of legal problems that they could solve. So quite often I would, go around the firm, talk to my fellow partners, and, I would tell them what I was doing, and I would ask about their practices and try and figure out like what their pain points were. And 9 times out of 10, I would tell them, okay, well, the databases and kind of the analytic approach that I'm taking in this product liability practice doesn't really translate to your, Beth Company litigation or your large scale deals. And so I often tell them, yeah, the tech doesn't really exist yet to help you. So it was really finding the right places. The skill there was really finding the right places in the firm where you could have this impact. And then, of course, generative AI comes out, and it just was immediately a game changer. Luckily, I had a team of developers and data analysts and data scientists underneath me at this point that I had built out over the years. So we were able to just immediately hit the ground running with AI and start implementing it into a lot of existing ongoing cases. It really proved the concept that it was, in fact, going to be really powerful. And I effectively found myself in the position where all of a sudden I could go back to all those partners I told I couldn't help before and be like, okay, the time is now, right? Now the technology has evolved where instead of legal tech only be able to help with like 10% of practice use cases, all of a sudden it's like 90% of use cases that can in some way be impacted by AI. And it just was such a clear sea change moment in terms of what the technology landscape looked like that, along the way, people had told me, you should go do legal tech. And I said, no, I think it's not quite as the technology is really not the interesting thing. The interesting thing is the application. And I think it's still true, but obviously legal tech itself is now, and legal AI is so interesting that I finally decided to make the jump and decide to pursue it full time.
Wow. Kyle, you talked about disruption and AI forcing the hand of sort of restructured fee agreements. And you were kind of talking about this a decade ago. Update now, like where do things stand? Because obviously there is some very simplistic truth to the idea that the benefit of AI runs in direct contradiction to the business model of large law firms, or just the traditional billing structure by which they were operating.
Yeah, I think from a level of like the receptiveness is to disruption is like 10 times, it's like through the roof, right? So like the appetite for disruption a decade ago was very low. No one wanted to be, and I remember being told early on by a partner that you didn't want to be too efficient. And I remember being like, wow, like if the clients could hear that, right? You just do, you want to be, we have an obligation to be efficient and to use kind of the best available technologies. The ethics rules have like anticipated this for years. Like, my entire career, the ethics rules have mentioned the role that technology can play. And now it takes on new meaning within AI. So I think there was, there was less pressure to do it then too. And it was a struggle. I mean, frankly, like the technology wasn't as capable. So like the amount of disruption that was possible was relatively low, and it was hard to find. So it makes sense that there was less reception to it then, less pressure to do it now. I think, the pressure on firms to do more with less or do more with the same, is ramping up. But the cat's out of the bag, right? Like at this point, I mean, everyone knows at this point that AI is going to have a big impact on law. How big of an impact is still sort of subject to debate. What this all looks like when the dust settles, how much of a disruption it's going to be, but it's going to have an impact. And ultimately it will be a force multiplier, and it will have, varying effects. So I think there are a couple of things to kind of keep in mind. One is that legal is a very diverse in terms of the practice itself, right? Like the tasks that lawyers do, it's very, very diverse. And so what litigators do versus transactional attorneys do is very different. And so AI is this broad-based general purpose technology, which is what's so amazing about it, that can have applicability in a lot of different areas, even where you don't have scale. But it's the way that it's going to play out is going to really be case specific, matter specific, client specific, right? It's going to depend on how much of a disruption it is going to depend on the bargaining power between clients and firms, the pricing pressure in a particular practice area. So there's going to be kind of differing business impacts and differing, practice impacts depending on what kind of tasks we're talking about. But the level of receptivity, is, like I said, the cat's out of the bag in terms of like it's going to have an impact, and so clients are expecting more and more. Virtually every single request for proposal that corporations send out to their law firms says something in it today about, what are you doing with generative AI? They want to know what the firms are doing, what investments they're making in there, how they're benefiting from it, how they're using it for other clients. Like, it's quite expansive sometimes what these request for proposals ask for. Sometimes they're very one-sided, where the corporations say, oh, we want you to take like all the knowledge and experience from your other clients, use that generative AI to like extract value, and then use it to our benefit, but we don't want you to use any of our data or documents to benefit anybody else. And so, that's going to have to work its way out. But now there's an expectation that they use it. What that translates to in terms of dollar savings is going to be different. But clients expect to see, some uplift in terms of quality, in terms of responsiveness, and ultimately in terms of cost savings thanks to AI. But it's gonna vary depending, like I said, depending on the nature of the practices.
For anyone listening out there who is thinking about making the switch to maybe a case-by-case basis one-time fee instead of a, ongoing hourly fee for services, what are the first steps they can do to really analyze, how do I build this fee structure? How do I understand the whole case with the technology we have and start the foundational work for this fee structure?
So it's a great question. I think that, so one thing, and I guess to the prior question too, is people who ask this, they're like, oh, it's going to be a disruption to the billable model. There's sometimes a naivety about like how work actually gets priced today. So the way that or pre-Gen AI. And so they talk about, oh, we're moving to value billing, as if that like sort of hasn't been happening. And I think the misconception is it's like people have this idea of like a taxi cab where, you get in and there's like this meter and it's just, it costs whatever it costs at the end of the ride. And the ride could be longer, it could be shorter, and that's the price you pay. I think that the real way that work gets sourced is, for the most part, is that that request for proposal process, right? In the pitching process. And so understanding that like when, let's say a corporation gets sued in a large, massive litigation that's going to be sprawling and go on for years, they then will send out requests for proposal to multiple different law firms, asking them to basically pitch for that work. And that's where that's that form that I mentioned before, where they'll say, what are you doing with generative AI? The firms come back and they'll say, okay, this is why pick us. This is why you should pick us. And oftentimes they'll send a budget over. They'll say, this is how much we anticipate this work, whether it's about the company litigation or a big transaction. They'll say, this is how much we anticipate it costing. And oftentimes that sets the client's expectations for the amount that it's going to cost. So when the client's picking, if they're choosing on price, and I think another layer on this is not all practices are, not all firms and practice areas are price sensitive, right? Like at the top of the market, oftentimes corporations are not picking on price. They're not picking the lowest cost provider. They're actually picking sort of the highest quality provider. And so if you can use AI to deliver higher quality results, then like it's not going to hurt you on the price side of the equation. So oftentimes they're picking based on quality. And so if it is in a somewhat price sensitive area, that the work where price does matter for why the corporation's picking one firm versus another, even forgetting AI, like there's still, the firm says, we think we can do it at, $500,000, and the other firm says they can do it at $1 million. Like that's, the corporation will choose the firm, if they're choosing based on price, potentially on the one that says they can do it for less. Now, of course, the questions would come about like, how do I know I'm going to get the same quality if one's offering it at $500,000 and the other's offering it at $1 million? How do I know I'm going to get the same quality? And of course, that's where AI comes in to say that's how I'm going to be able to undercut my competitors on price. Like if that's the strategy you're choosing to actually use AI to compete on price, you could say, well, yes, we're going to compete on price, but how are we going to ensure the same quality? Well, that's where we're going to use AI to kind of make up the difference, because it'll be fewer hours, but we're going to use AI to deliver to ensure the same quality results. So I guess with that background in mind, like that's where I would start when I think about repricing. It's like thinking about how you would price the work today. Sometimes that's historically looking, it's like, and frankly, that's how most firms price work, is they say, what did it take to do it last time? because the work is metered out on a billable hour, though, there's some protection. But if you blow through that budget, that $500,000 budget you cited to the client early on, if you blew through that, the firm might take a haircut on that too, and to kind of come in line actually charging. So they might just write off that additional time. Obviously, if it looks like midway through the work that it's going to take twice as long, they're going to go back to the client and say, hey, this is taking a lot longer than we thought. Clients usually have repeat relationships with their firms, right? So it's not like there's never really clients aren't really in the business, and firms aren't in the business of really putting the pressure on the firms or vice versa, right? They know these are repeat relationships they want to foster. And so they try to be reasonable on both sides if it is a lot more expensive than it was before. But I do think, what I've seen in terms of fixed fee arrangements broadly in the industry is quite often they're mispriced, kind of one way or the other. It's not inconceivable that on a fixed fee matter, if you don't know what you're doing, you don't know your actual cost structure, the firm takes on a risk there that, like, if you do a fixed fee, that they'll actually lose money on that work. And so firms have to be careful about how they price this work, and firms frankly are very unsophisticated about how they price work. And the billable hour model, when that was how you grounded all of your the feed generation, that provided some protection because it shifted the risk off to the client, because if work did turn out to be a lot more expensive, you could charge additional money. Of course, you'd always go back and renegotiate. So I think that it's sort of a chicken and egg problem, ultimately, is how it's going to play out with AI. So you have to, in order to intelligently price, you have to understand your internal cost structures, which is easy if you have the billable hour, because it perfectly aligns that with revenue generation. But on fixed fees, there's a risk. And so the benefit, though, is that as AI helps automate and augment more and more legal work, you actually becomes more predictable how much work is going to be involved, or how much your cost study of the equation becomes much more predictable. So the better firms get with AI, the better they're going to be able to understand their internal cost structure, and then the better they're going to be able to price things on a fixed fee matter. There will be some bumpy roads ahead as firms make this transition. With the chicken and egg problem, you sort of have to learn how to use the AI first and build the AI workflows first underneath without changing the fee structures first. You have to take the world as it is, with fee structures being what they are, and then you have to kind of learn in that environment how to do it. And then once you've learned how to do AI, build the reusable workflows, all this kind of stuff, you then can be in a position to start offering new fixed fee arrangements. And typically it's going to happen on a gradual basis, right? The best place to do this is in new work. So you've learned AI via your existing matters, and then when you get the new RFP comes to the door, you then are in position to say, hey, this is the AI, the skills we've learned with AI, these are the workflows we'll be able to automate with AI, and then you can offer it on a fixed fee basis. Sort of just that same value pricing you would have done before, where you budgeted for it, but now you can actually cast it as a fixed fee. And you can put provisions in the agreements that say, look, if it turns out that we're taking a real beating on this fixed fee arrangement, if it turns out to be 25% cost above our cost or whatever, we'll come back and renegotiate in good faith. And I think those are some, especially for repeat relationships, those are safe ways to kind of go about implementing fixed fee arrangements.
It's a great tip.
Yeah, seriously. Kyle, that also entails some sort of internal champion or set of internal champion, people who are willing to sort of change their workflow to take a flyer on this new technology. My experience with law firms is that it's a mixed bag, right? I mean, obviously, who is going to be that? And then you also have naturally, the AI skeptic or the maybe seasoned practitioner who's like, no, we're just not doing this. Or how do you engage with them? What is that process like? And are you seeing that change sort of just across law firms as well? Are you seeing the adoption sort of shoot up a little bit more than you had expected?
Oh, yeah. I mean, it's quite remarkable how quickly people are changing in terms of the skeptics. There certainly are skeptics, but at this point, it's not like they don't think the technology can't do things. Usually it's around they're like, oh, the risks of what if it makes a mistake and things like that. So the skepticism, frankly, has become more nuanced and less broad-based. It's not that it's almost because they recognize how powerful, and as the technology gets more and more impressive, right? The risk of over-reliance goes up. So it's almost because the technology is succeeding and is having real impact and has real value that actually the skepticism is actually ratcheting up. So it's probably a healthy thing, actually, that there's the skepticism getting more nuanced in that. I think that broadly, when a firm's picking sort of where to start, there's sometimes firms want to go big, sometimes firms want to go, start smaller. There's pros and cons to both approaches. But ultimately, you are going to, even if you want to do a broad and rollout, there's oftentimes And I guess I'll kind of frame this. There's kind of two layers at which I think AI, just to kind of set kind of the context here. I think there's two elements of learning that firms need to do. The first is what I would call muscle memory. And the second is really building what I would call reusable workflows. Okay, so the first thing that firms need to do is create AI literacy, fluency, throughout their organization. So this is just having AI be one of the tools in the lawyer's toolkit that when they need to use it, they think to use like the AI tool, even something as simple as like, a chat assistant or like a data extraction, like a tabular review, or you can do bulk extractions. These are tools that just simply did not exist for the majority of practicing attorneys' careers. If you are a senior partner or you are a senior associate, even like you learned to do things the old way, and there's now this new technology. Just think by analogy to like the electronic research when it came out. There was people have been doing legal research for years. They did not have a skill. They did not know any skills with how to use electronic. There's different skills, terms and connectors, right? Like Boolean searching. That's a new skill set that electronic research required that was totally different skill set than what you would do if you were looking through the stacks, right? Going through the physical books. And so I wasn't around when this transition happened, but I can imagine there were partners who swore by the books and said, no, maybe that electronic research is good as a first pass, but there's nothing like going back to the stacks and actually reading the books. And man, there was like a lot of like, people concerned about, if they're going to overly rely on the search capabilities and they're not going to have that the learning that comes with, mindlessly, wandering through the cases, reading stuff on physical paper. So there's this new skill set that's emerging that people need to learn. So I think that's one good analogy, but I think it's honestly going to be a bigger transition than just the electric. It's going to be bigger than just that. It's going to be much more around AI than just like electronic research. But the first thing is the muscle memory, right? So it's just for the partners, for the associates, and for the partners especially, these are people who made their fortunes doing things a certain way. And so it's really hard for them it's somewhat of a challenge to walk into a room with a person who's been doing it for 30 years and they, have made tons of money, millions of dollars doing something one way and then say, what, now there's a better way to do it. It is a challenge to convince them. But ultimately, organizations need to create, the argument for making these tools broadly available is you need people to kind of learn these tools in some way or another, so that when they have the need, when they're doing it, like preparing for deposition, for example, they know how to do that today, but they need to realize, okay, there are now tools available that can help them prepare for that deposition better. Or if they're doing it, staffing a due diligence, there's the old way of doing it. They need to know these tools are available so that they can staff a matter leveraging these tools. And of course, the people who they're going to staff that matter with also need to know how to integrate the tools kind of as their day-to-day life. So one level at which firms need to do adoption of tools is just building muscle memory kind of broadly throughout the organization. So this is just yet another tool in their toolkit that they can bring to bear when they're practicing. The next layer is the building of reusable workflows. And so this is where kind of the cooler stuff, right? This is where you take the knowledge and experience of attorneys in the firm and you build that into these reusable workflows, these little applications that can be rerun over and over again. And that takes a little bit more skill. That's not just muscle memory. That's like, it actually takes entirely different skills to build those. Not entirely, but like there is a different skill set, a different kind of level of experience that's required to build those. And oftentimes that's where like knowledge managers come in, innovation attorneys can come in. We have a large team of legal engineers here at Legora that we bring in to help enable our customers to build that. So I think going back to your question about some of that's just framing, but like skeptics and champions, finding champions is important across the board for both. Like you need champions who can say like, hey, look, this is how I'm using it in my day-to-day life. Especially like as a vendor, we have a lot of experience doing this, but like attorneys within a firm are going to trust the attorney sitting across the hall from them a lot more. And so ultimately to be convinced, especially to convince the skeptics, it's going to take, their fellow partners saying, hey, look, something as straightforward as this. We used, my team learned AI, we upskilled on AI, we started building reusable workflows using AI, and we just won $5 million worth of work because of that. A new client came in the door and we put our pitch together. We mentioned all the AI that we're doing. We came in at a competitive fixed fee, or even on an hourly basis, right? You could still come in at a lower cost on a hourly fee basis because you were using AI to deliver additional value. We won $5 million in new work on a fixed fee basis or some other basis, thanks to the work that the time we spent investing in AI. And like that story, like that's what's going to convince most partners at firms, is when we have those stories. Still early days as far as those go. I mean, we have clients who are doing that every day now. But it's just going to take a time, because fee arrangements take a time, like to get new clients in the door. That's something that does not happen overnight. Fee arrangements are sticky. So yeah, the skeptics, they'll be there. I think that's healthy. I think the champions are going to be the biggest change agents in firms. And then the question of where to start. Broad-based, you have to do it kind of across the board. But where, for those reusable workflows, where do you start? I think that there's a science and an art to picking those practices. But I would probably start where you already have fixed fee arrangements, right? Like, don't, if a partner came to me and said, hey, I've got this hourly practice, there's no competition in this space, we're the only ones doing this work, we could charge whatever we want, we could take as many hours as we want, no one cares, but I think I could do an AI workflow, I'd be like, well, I don't see the pressure to start there. I probably wouldn't start. And they were like, oh, if we did that, we would reduce our hours in half. And I'd be like, well, I probably wouldn't start there as a firm, right? I'd probably start somewhere where you already have fixed fee arrangements, or where there is price pressure, so that you actually are competing on price, where you actually can very quickly turn this into increased revenues. But if you're the only, if you're in that other situation, I would probably let that, that'll come, but there's no urgency to start there.
Makes complete sense. And I'm curious, just for those listening, maybe someone who has a smaller firm and wants to implement AI, what is an example of a good workflow they can begin with, just to introduce some of the basics and kind of get their feet wet with building like a practical workflow, so they can see the change in their firm and then maybe want to invest as their firm grows larger? What is a good intro workflow that they can begin with?
There are a lot. I mean, obviously it depends on what practice we're talking about, but litigation, again, we talk about workflows, we can mean like daily work. What I would call is like, there's like, I distinguish between like daily work, and I guess it's kind of a term of art. When I think of a workflow, I think of an automation, something like, that is kind of bundled together, because that's just how we think about it. But it's like part of their daily work, and that's not the muscle memory, it's part of their daily work, right? And so I think you always have to start with daily work, right? You just have to start with like, what are the things you're doing all the time? What are things that you're doing for clients where you can't bill for it? People talk about, there's obviously non-billable time, business development tasks the attorneys have to do. Those are great places to start. But then there's oftentimes, for some clients, they're like, they don't pay for, first year, some of them won't pay for first year associate time. Okay, well, you go wild then for those, because you still need first year associates on those matters. And if you can't bill for that time, well, then like that's where, and they need to learn anyway, and first year associates don't know what they're doing anyway. So like maybe start there. So again, it's always going to be really specific to the practices, but broadly speaking, I would say just make sure people know there are real ideas out there. It's things like, deposition preparation, analyzing deposition transcripts, even things like analyzing precedents and case law, being able to bring those into something like what we call tabular review. So I can analyze 30 or 40 different cases to find the best case that I want to use to cite in my brief, right? Like, because oftentimes when you're writing a brief, you can cite to, like, you could pick 4 or 5 different cases for the same proposition, but maybe there's, the judge you're in front of, that's their favorite kind of case to cite to. And so if you can uncover that fact by loading a bunch of the opinions that judge, has written into Legora, and then analyzing it to find out which ones they prefer to cite to, you could just, it's those quality of life things that the judges will notice, and it's attention to details things that judges will notice that can make a big impact. On the transactional side, I think due diligence is like the go-to, right? Like being able to do large-scale due diligence, contract review, using AI to do kind of at least a first pass of that, or help triage that. You still want to have lawyers, in the loop. You still want to have lawyers double-checking things, but to be able to triage things so you can, for example, instead of having, a bunch of mid-level associates assigned to a due diligence, you could maybe have you could upskill some of your junior associates to be assigned to that. And they can be using AI. You can use AI as the first pass and triage it into sort of like those contracts that need to be double checked. And then those contracts that are probably fine, you do need to double check them, but like, there's not as much urgency to that. For example, in a transaction, maybe you're reviewing underlying leases as part of a transaction for the target has previously entered into, and you need to make sure those leases are, comport with like the terms of, like, say, the purchase agreement. And so some of them might need to be modified or amended before you can close the transaction. And so you would triage it into those that need to be amended, and then you could have those done by your senior associates, your mid-level associates, whereas the junior ones are just double checking everything and make sure the AI didn't miss anything. So yeah, it's highly varied, but those are just a couple of examples that I think firms often will want to start with.
Kyle, earlier you were talking about something that we all know to be true, which is we don't really know a few years from now, where the dust is going to settle, when the dust settles, what this whole, what it's going to look like. I mean, I'm curious, like, what are a couple predictions? Where do you think this is going? Where do you think this space is headed? And you can be as granular and specific as you like, or I don't know, but I'm interested to hear you forecast a little bit.
Yeah. So, getting back to the kind of analogy of the electronic research, I kind of think there's sort of two prior precedents that we can look to for inspiration as to how this plays out. One is, because this isn't the first time that the kind of innovation has come to legal. People act like it is, and it certainly is the biggest one, and we're certainly ripe for disruption. But like we've had two prior waves. The electronic research and electronic discovery. All right. And so electronic research, I kind of already talked about, which is AI going to be more like electronic research, electronic discovery. And I think that for electronic research, here's how that played out, right? So it's like this new technology came about. Some firms early on adopted that. They were able to do better research, find better precedents, win cases. There was like a strategic advantage if you were one of the early adopters. But it very quickly became table stakes, right? The dust settled relatively quickly, and it was just the new normal. It was just like, it's a one view of the future of AI is like that, where it's like, in 5 years, everyone has legal AI. It's just, you have to have it. You're not practicing law. It's borderline malpractice, if not literally malpractice, not to use it at that point. But like basically everything has changed. I mean, this is the kind of the certainly not what I think is going to be the case, but it's like, it's where it's like all the firms look the exact same. The fee structures are almost the exact same. Like the associate partnership model is the exact same. Like everything, it looks the exact same. It's just like new baseline. And so the question there is like, why do I need to do it? It's like, well, you'll go out of business if you don't, right? And everybody will see the writing on the wall and inevitably adopt these tools. The other, though, more interesting example is electronic discovery. So in electronic discovery, pre-electronic discovery, so this is like 20 years ago, where this transition started really taking off. You had, discovery used to be like the bread and butter of virtually every single firm that did any kind of litigation. It was a core source of revenue for firms. It was a core source of margin for firms, a core source of leverage for firms. It was a core source of training your junior associates, having them level up and get experience doing the work. And it was obviously on like hourly fee arrangements. But then what ended up happening is technology, in fact, the first wave of AI, right? Machine learning, predictive coding, like that first generation of AI coming to law, like came about and started to disrupt that segment of legal practice. And so it was confined. And so, a lot of lawyers at the time, like who weren't in the discovery space, got to like rest easy, being like, oh, okay, that's not going to affect my practice. Like the predictive coding stuff, that won't really come into any other areas. So it was very confined, which is sort of nice for a lot of people. But what happened there is a lot of firms looked at it and said, okay, this work is being commoditized. And so they, particularly top tier firms, they said, you know what? We don't do commodity work here. We're legal minds here. We are super sophisticated. We think that we only do like the highest level of legal services and legal work. And so if it's becoming commoditized, we don't want that work. We don't care. We're going to lose the work, but we don't care. The risk, though, is you're losing the client relationships that come about. You're losing not only the revenue, you're losing client relationships, that work, and those relationships are now going to your competitors as a result. But what did we see happening in electronic discovery is we saw, one, billing model changes, right? Like virtually none of that work is being done on a billable model basis anymore. Two, virtually no large law firms do, the bread and butter of document review themselves anymore. Like they outsource that to either e-discovery first law firms, and the analogy there would be like AI native or AI first law firms, the ones that lean into this, or to like ALSPs, like new market entrants. So as far as predictions go, the question is, which is it going to be more like? I think it's obviously going to be the new baseline, like electronic research, but I think it's going to have the much more disruptive, industry-changing, practice-changing, business model-changing impacts electronic discovery had. Because now, like as mentioned at the very beginning of the call, like now the technology, it isn't constrained in what it can do. It can really go to almost the outer limits of legal practice. And so I think the future is going to be more diverse. Do I still think there will be massive law firms? Absolutely, there's going to be massive law firms. In fact, I think there's going to be an acceleration in the M&A trend in firms that we're seeing right already. That's been playing out across a couple of years. There will be there's moats that can be created by merging, particularly if you can get access to sets of data that the models aren't trained on. Right, so the models are trained on all publicly available data, but then that just means that if you have access to a private set of data that no one else has access to, that is actually even more valuable. Because it becomes a competitive advantage. And so if you can merge with other firms that also have private sets of data informing, like, say, private M&A transactions, like what's market, being able to say what's market in private M&A, if you can do that because you have a larger data moat, like you're going to start to see increasing M&A in that space. So I think that as far as broad predictions go, you will see new market entrants. Like we're already seeing that, right? We're seeing AI first law firms. I mean, super early days of that, but I think we're going to continue to see that. I think that ultimately some of the work will actually go in-house. So actually one difference from eDiscovery is, there just wasn't a natural fit for like discovery to go in-house because litigation is one of those things you classically outsource. But because this technology is broader, like there will be instances where actually there's advantages going to in-house. But I do think like I don't think that's going to be. I mean, it'll be significant, but it won't. It's not like it's going to totally disrupt law firms because there's economies of scale. There's competitive advantages that law firms have doing certain types of work, right? They do it all the time, and like even corporations, if they could do it internally, like they just won't have that breadth of experience, like talking about with the private data sources, they won't have access to that private data source. So there will just be economies that scale that the law firms will continue to have and will actually grow with. That will prevent some work from going in house, but inevitably some will go in house. As in-house teams level up as well. And like I said, new market entrants are going to come in, and then we're going to see large scale, pricing changes. Not entirely, but at least, oftentimes there'll be hybrid fee arrangements, particularly in the interim, where certain tasks within practice become fixed fee basis. And then others just still remain with the strategic work, is done at a at an hourly fee base.
That is a fascinating prediction. And I love how you mentioned the new frontier is really going to be against your competitors' data. The acquisition of data and private data. Before it used to be how many clients can we get? They have way more than ours. We should merge, whatever it may be. There were new reasons for merging back in the day, I guess. Those are old reasons. And now we have one that's particularly set on data and how that can make you the differentiator as a new law firm or a bigger law firm. Fascinating, really is, the more I think about it. Now, I have a question for you because you have worn two hats here. You've been an attorney, and you still are an attorney, but also you work in the legal tech AI space as well, legal tech space as it is. And your company deals with AI embedded into the legal tech tool. We're seeing a development where legal tech companies depend on these massive AI companies to kind of feed their own product, right? To be able to create new innovations with AI and find new ways to embed it into their product to create something new and different. But we're also seeing the increase of these same AI companies develop either plugins or just ways to analyze that same industry that we're trying to create legal tech innovation in. What do you think is going to be the differentiator for legal tech companies when it comes to the competition? Used to be you versus another legal tech company. Now it's you versus the AI companies that you're very much getting the data from. What do you think is going to be the differentiator here to really create innovation?
Yeah, I mean, people have been wondering about this actually for a long time. Like even if you talk about like document management, right? I mean, there's specialized the legal tech companies that do document management, and of course, then Microsoft has like SharePoint, and they do document hosting, right? So people have asked for years, like when's Microsoft going to come in and start to disrupt the DMS space in law? And what we've seen is historically they just haven't, right? Like the total addressable market of law legal, it's big, but it's peanuts compared to like the broader enterprise market. And obviously legal carries with it specific risks, right? That have, you can just see this in terms of funding. I mean, legal, obviously there's lots of funding happening in legal tech now, but like, historically, and I think even today, it's like for the size of the industry of legal is, it's, total roughly $1 trillion market globally for legal services. The amount of money that's been invested in it is actually relatively small. Like you would actually, all things being equal, it's an underinvested industry to this day even. And those risks are actually why like there's been an underinvestment in for like VC money and PE money. So, and those are the same reasons why those same sort of institutional barriers to entry or kind of complexities, risks that are associated, there's unique to legal, have made it such that other bigger players have not entered it. So I think those sort of barriers to entry will persist, right? Like the needs of legal are always going to be nuanced. That said, like I think it's great that the foundational model companies are leaning into legal. Because ultimately, a company like Legora, like we don't train our own models. We use the best-in-class enterprise models, models from Anthropic, which is a major partner of ours. In fact, we mostly use Anthropic. So, that's the engine underneath our hood. The way we see it is it's like there's engine manufacturers for these models, and then there are different companies who like buy engines and they put them inside their cars. And there's like you can have the same engine in a tractor that might be in like in a Jeep or whatever. I don't know cars, so I'm sure I just made a lot of people cringe there. But the ability to have like the same engine that has different purposes that can be put in different cars for different to different ends. And so we're basically taking these engines and we're building a car or this application where the application layer that's meant to address like the actual day-to-day needs of large law firms and in-house and mid-sized firms as well as in-house counsel, which of course are different. So the ability to integrate with different data systems, obviously MCP is going to help in that, but like MCP can't do everything. But the ability to integrate into like their document management system, their time and billing system, into legal research provider data, right? Like the ability to integrate into both private data and public data sources, and then bring those together at the workflow level, which is where we operate. You have the application layer where people can use our tools to help on their daily work, but also to build out reusable workflows. Like that's the layer that they're going to like. There's a lot of services that we can provide around there, a lot of functionalities, usability, user experience at that application layer that so much of the value, even something like ethical walls, right? Like going back to the DMS example, like that was one of the problems that is solved for by like a legal specific DMS that isn't going to be solved for by a SharePoint, right? And so that's one of the reasons why they would come in. So we're ultimately, yes, Anthropic's going to be helping out with building models that understand legal problems better, and that's awesome because we rely on that engine. And so like we've seen, you take a step back, like Claude has gotten so good. Claude Code has gotten so amazing over the past 6 months because they've just been spending tons of money training it on coding use cases and reinforcement learning tasks and testing, and it's made it phenomenally good. Even within the past 2 months, like it's gotten phenomenally good. We use AI to help build our code here, and so I was talking to developers or some of our engineers last week, and they're like you wouldn't believe how good Claude is getting at writing code. And so as Anthropic shifts its attention or broadens its attention to legal problems, that just means it's going to get better at solving legal use cases. And so we as the application layer are just going to get even more valuable as a result. And I think ultimately they're not going to want to solve all of the kind of the long tail of issues, not to mention all the sales issues that go in, right? I mean, selling into the whole other barrier that I didn't talk about of why people to enter is selling into law firms is, its own little complexity, right? Like that's why it's there's especially people will transfer from one legal tech to another because they have that experience selling into large law firms, which are very different entities than any other large enterprise. And so there will be other reasons why there will be plenty of room for legal tech companies, legal AI first companies to persist and to succeed.
Amazing.
Kyle, we always wrap our episodes here with the same question. I'm interested in your answer. What is the hottest take that you have on the industry right now?
Yeah, I probably would be the Anthropic, coming in right now to the space. I mean, that's certainly where I'm getting a lot of calls from, and a lot of people on LinkedIn. It's certainly the hottest topic right now. I think that one of the hottest takes would be, this idea that like traditional skills aren't going to matter anymore. I actually think they will. Like, I think that like when the dust settles, like the world will be different than it is now. And it's, of course, a moving target, but like there will be some firms that are going to get ahead. They're going to leapfrog other firms because they leaned into AI, and like having invested heavily in AI and building out these workflows, right? Like it's going to be a new paradigm for competition in the market. Firms don't compete on their intellectual property today, full stop, right? Like that will be something they compete on in the future. So like the world will be very different. But I do think there's still going to be like the reasons you hire attorneys, the judgment, the kind of incentive structures around why you pick top tier firms or pick one firm over another. A lot of that isn't going to change. And so there will be a familiar world. I likened it to like if I were to go into a coma and wake up, like, 10 years, like you might, on the surface, a lot might seem similar. Like you'd still see, the big name firms, a lot of the big name firms, maybe some of them will have disappeared or merged, and you'd be like, oh, those guys must have merged. But a lot of it will look the same on the surface, but under the hood, a lot's going to have been changed, right? I think that it's going to be, we're going to, in terms of like fee structures, the Big Four provides another kind of instructive example where they used to do everything on an hourly fee basis. Like 90% of their work was hourly fee basis. Now it's something like 80 to 90% is done on a fixed fee basis, right? So like that radical flipping of how important fixed fee models are, certainly over the time horizon of 10 years, you could easily imagine that flip happening. But I also think that even as expansive as it is, I think a lot will stay the same. The skills of being a lawyer, how you do it will change, but that it'll still be important. People still going to law school, in the future. But so a lot will be the same, but a lot will be different really under the hood.
I love it. Yeah, no, I really share a lot of what you just said there. And I think it lines up with what we're seeing. And it seems like a natural endpoint, a natural trajectory. All right. Well, that's a wrap on today's episode of Between the Briefs. And a big thank you to Kyle Poe for sharing his insights on legal innovation, AI strategy, and everything that it takes to bring tech into legal practice in a meaningful way. Adrian, you have anything else that you want to add?
Absolutely. Thank you so much, Kyle. This was huge. I really loved your takes, especially around data and just how to really integrate AI into a firm and the value that legal tech can bring to any firm, especially with AI. So thank you for sharing that.
Awesome. Thank you for having me.
Of course. And to our audience, be sure to subscribe so you don't miss future episodes. Thanks for listening. Stay curious, stay thoughtful, and we'll see you next time on Between the Briefs. Up next on Between the Briefs.
When Erica, Gianna, and I were doing defense work, we actually were medical malpractice defense lawyers. So we represented hospitals, doctors, healthcare facilities in these cases. And we learned the tricks of the trade, and we took a lot of pride in that work. We loved what we did. We loved working on those cases and defending healthcare providers. They are heroes in a lot of ways. But I think that when we switched to the plaintiff side, our dad always taught us we need to fight for people who can't fight for themselves. We need to fight for the patient who had a catastrophic injury due to a medical error and can't work anymore and can't support their family. On the other side, we were defending very sophisticated hospitals and doctors and healthcare systems, and that was great. But I think we take a lot of pride in helping people who can't fight for themselves.
Stay tuned for the full interview coming to you soon. Between the Briefs is brought to you by Steno. To find out more about Steno and how we combine exceptional court reporting and litigation support services to deliver a superior litigation experience, visit steno.com. That's STENO.com. And then make sure to search for Between the Briefs in Apple Podcasts, Spotify, or anywhere else you get your podcasts, and click subscribe so you don't miss any future episodes. On behalf of the team here at Steno, thanks for listening.